The Child Care and Protection Act, Section 76, Methods of Dealing with Child Offenders, Subsection 1. Where a child has been found guilty of an offense before a children's court, that court may, subject to the provisions of this act, make an order: A. Dismissing the case. B. For probation under the Probation of Offenders Act. And C. Placing the child either in addition to or without making any other order under this section for a specified period, not exceeding 3 years, under the supervision of a probation and an aftercare officer or some other person to be selected for the purpose by the minister. So if seen fit, they might dismiss the case or make an order for probation or placing the child either in addition to or without making such order under probation for a period not exceeding 3 years. All right, we continue. These are what the children's court may do if a child is found guilty of an offense. D. Committing the child to the care of any fit person, whether a relative or not, who is willing to undertake the care of the child. E. In accordance with subsection 7, if the child's parent or guardian consents to the making of the order. F. Sending the child to a juvenile correctional center. G. Ordering the parent or guardian of the child to pay a fine, damages, or costs. H. Ordering the parent or guardian of the child to enter into a recognizance for good behavior of such offender. Okay. So, two of the things here that I'm seeing, they may order the parent of the child to pay a fine, damages, or cost to cover the judgment or to cover cost of any article that the child might have destroyed or damaged, etc. And also sending the child to a juvenile correctional center. All right. Yes, those depend on the seriousness and the nature of the offense. Subsection 2. And under this section, other than an order under subsection 7, may be made against a parent or guardian who, having been required to attend, has failed to do so. But save as aforesaid, no such order shall be made without giving the parent or guardian an opportunity of being heard. 3. Any sums ordered under this section to be paid by a parent or guardian may be recovered by duress or imprisonment. Hear that? And in default of such recovery, such parent or guardian may be imprisoned with or without hard labor, as if he had been convicted of the offense in respect of which the child was charged, provided that in determining the sentence to be imposed under the subsection, the court shall take into account the impact of such sentence on any child of the person to be sentenced. So you see, your child commits an offense, you might be ordered to pay money, and if you fail to do so, you might be imprisoned as if you were the one who committed the offense. What does the last part here says? In handing out down sentence, the court will take into account the impact on the child of their parents' imprisonment. Right, so this section forces you to make sure that your child, your children, behave themselves and not commit such offenses. Alright, subsection 4. A parent or guardian may appeal against an order made against him under this section as if he had been convicted by a resident magistrate court of the offense in respect of which the child was charged. So you might appeal as well. Subsection 5. The provisions of subsection 6 shall apply in any case where A. An order had been made under subsection 1F in respect of a child who has attained the age of 14 years, and B. The minister at any time during the period of the child's detention at a juvenile correctional center establishes to the satisfaction of the children's court that the child is of so recalcitrant a character that it is not expedient that he should continue his detention at such center. I just looked up the meaning of the word recalcitrant. It means having an obscenely uncooperative attitude towards authority or discipline. A person who is obstinately uncooperative, with an obstinately uncooperative attitude. So that means, here, let me read that part again. The minister, at any time during the period of the child's detention at a juvenile correctional center, establishes to the satisfaction of a children's court that the child is of so recalcitrant a character that it is not expedient that he should continue his detention at such center. Subsection 6. The court may, notwithstanding anything to the contrary, direct that the child be detained in such place, including an adult correctional center, and for such time not exceeding the unexpired portion of the period during which he could have been detained in the juvenile correctional center under the authority of that order and on condition as the court thinks fit. So the court can move that child from the juvenile correctional center in the custody. Let me see. The court may, notwithstanding anything to the contrary, direct the child be detained in such place, including, in adult correctional center. May move, so the court can move a child who is uncooperative from a juvenile correctional center to an adult correctional center. Right? Okay. Subsection 7. An order under the subsection may A. require the child to remain at a place specified in the order for a period of time, so specified here in after called a curfew order. B. Refer the matter for mediation by an appropriate mediator, hereinafter referred to as a mediation officer. C. Require the child to perform unpaid work for such number of hours, being in the aggregate not less than 40 or no more than 360 hours. Okay, so between 40 and 360 hours. of community service, as may be specified in the order hereinafter referred to as a community service order. Subsection 8. The following provisions of the Criminal Justice Reform Act shall apply, with the necessary modification, to an order under subsection 7K. So, to the order to perform community service or to mediation. So here they are. A. In the case of a curfew order, section 13(2) to 6 and 14. That's of the Criminal Justice Reform Act. In the case of a mediation order, section 16, subsection 2 to 7, so, however, that the child's parent or guardian shall be the participating party in the mediation on behalf of the child. And C. In the case of a community service order, section 10, subsection 2 to 5, and the proviso to section 10, subsection 1. Subsection 9. A court before whom any child in respect of whom an order is made under subsection 7 is brought, if satisfied that the child has failed without reasonable excuse to comply with any of the requirements of the order, may, right, so if the child does not comply, these are what the court may do. A. Without prejudice to the continuance of the order, impose on the child's parent or guardian a fine not exceeding $2,000. Or B. Revoke the order and deal with the child for the offense in respect of which the order was made in any manner in which the child could have been dealt with for that offense by the court if the order had not been made. We will look at section 77 in our next video.